Probably
Yeah.
they can gavel.
Happy Lane, but partnering and call for seconds.
Will the Senate please come to order? We will take a moment of silence in lieu of a devotional today. Thank you. Are there any announcements? Seeing none. We have H 231, an act relating to technical corrections to fish and wildlife statutes, will be referred to the Committee on Finance under Rule 31. Orders of the day. H1, an act relating to accepting and referring complaints by the State Ethics Commission, which was passed by the House on January 9th of 2025. It was referred to the Committee on Government Operations, which reports it has considered the bill and recommends that the Senate propose to the House that the bill be amended as it appears in today's calendar, and that with such proposal of amendment, the bill ought to pass. Listen to the second reading of the bill.
H1, an act relating to accepting and referring complaints by the State Ethics Commission.
I recognize the senator from Rutland District, Senator Collmore, for the report of the committee.
Thank you, Mr. President. Senators can find the bill on page 1604 of today's calendar. And as we walk through the bill, I would ask the senators to remember 2 points. One is the constitutionality of this and also funding. Some of you couldn't remember House Bill 1. It's a follow-up to the ethics bill that the General Assembly passed last year. It was near the end of the session. That bill, H 875, expanded the powers and duties of the Vermont State Ethics Commission. And for members who did vote last year, you'll probably recall a lot of the focus was on that bill's provisions regarding municipal ethics. However, what was also included in the bill were provisions relating to the authority of the State Ethics Commission when it refers to complaints to either of the legislative panels, to the judicial branch's 2 separate boards that have disciplinary control over judicial officers and attorneys, and also to the executive branch. It wasn't until after the adjournment of the 2024 biennium, after the bill was enacted into law, that constitutional issues were discovered in some of those provisions. Specifically, the language of the 2024 Act would require the State Ethics Panel, the House Ethics Panel, Judicial Conduct Board, and the Professional Responsibility Board, which regulates attorneys, to all consult in writing with the Ethics Commission on any complaint that the Commission referred to them regarding the application of the State Code of Ethics to the complaint prior to any of those entities being able to make a determination on the complaint, meaning either closing the complaint without further investigation or issue findings following an investigation. And that is an issue because by the Vermont Constitution, each legislative chamber has the exclusive authority to judge its members' qualifications. Similarly, the Vermont Supreme Court has, quote, disciplinary authority concerning all judicial officers and attorneys at law in the state. And those legislative panels and judicial boards were created to help carry out those constitutional functions. So the language of the statute attempted to control constitutional powers of the legislative and judicial branches, but statute cannot control the Constitution. In addition to these constitutional concerns, we also heard the committee from the judicial branch that it would violate their board's strict confidentiality issues to consult with the Ethics Commission in the manner that the 2024 Act would have required. And as we heard from both the Senate and House ethics panels, that the statute cannot control a chamber's legislative procedure, which is also what the 2024 Act attempted to do. In addition, the powers of the State Ethics Commission are scheduled to expand in September of this year to include investigations, hearings, warnings, and reprimands. However, the State Ethics Commission lacks the staffing and funding to adequately implement its expanded powers. Most notably, the commission lacks a licensed Vermont attorney on its staff, which is important as the commission would be empowered with interpreting law, issuing subpoenas, and enforcing violations. So H1, as it passed the House, addressed some of the issues by requiring the Ethics Commission to provide its advice on the application of the State Board Code of Ethics when it refers a complaint to one of these legislative or judicial entities, so that the entities have this info up front. This alleviated the specific concern regarding statute attempted to control the constitutional authority, but the Senate Government Operations Committee also determined that required consultation with the executive branch after the referral was unnecessary, and thus H1, as proposed by the Government Operations Committee, would require the Ethics Commission to provide its advice on the application when it refers a complaint to the legislative, judicial, or executive branch. So that is the background, and our Committee on Government Operations recommend the bill be a strike all, and I'd like to just walk you quickly through the bill as proposed by the committee. Section 1 amends the consultation requirement in Title 3. First, in subsection B, it strikes a reference to section 1223A because it doesn't exist. It also strikes the authority of the commission to refer complaints to itself for enforcement. This is just a delay to 2027 when the authority will be reinstated under section 2 of the bill. Next are changes in section 1223, subsection C, and subdivision 1, the language applicable to referral of complaints by the commission. It replaces the requirement that the legislative, executive, and judicial branches consult with the commission after the commission refers a complaint to a branch. Instead, the commission would be required to specify any application of the Code of Ethics to the allegations in the complaint and then include a recommended action. The new subdivision C2 would confirm that any advice the commission provides to a referred entity is confidential and non-binding on the receiving entity. Section 2 amends Title 3, Section 1223, effective September 1st, 2027, to reflect that the commission may refer a complaint to itself for review and potential enforcement when the commission's enforcement authority will be effective under the government operations recommendation. Section 3 amends Title 3, Section 1231, related to the confidentiality of records produced or maintained by the State Ethics Commission in subdivision B6 to strike references to the records of consultation. As there are no more consultations required, there will be no consultation records. Section 4 amends the effective dates to Act 171 of 2024 to extend the effective date of the State Ethics Commission Expanded Enforcement Authority, that is, extending the effective date of this authority from July of 2025 to July of 2027. And Section 5 is the effective date for Sections 4H1. The committee heard from a very long list of witnesses, including the clerk of the House of Representatives of the Vermont General Assembly, John Bloomer, the Secretary of the Vermont Senate, Carolyn Anderson, the Chair of the Professional Responsibility Board, Merrill Bent, the Chair of Judicial Conduct Board, Therese Corsone, State Court Administrator, Chris Davis, Commissioner of Vermont State Ethics Commission, Christina Sivert, who's the Executive Director of the State Ethics Commission, Paul Gillies, Vermont Attorney, Peter Teachout, Professor at the Vermont Law School, Jay Johnson, the General Counsel of the Governor's Office, Thomas K. Jones, Professor at the University of Connecticut, Ben Kingsley from Campaign for Vermont, Representative Martin Lalone, who's chair of the House Judiciary Committee, Larry Nobens, a former executive director of the State Ethics Commission, and Michael O'Grady, who is the Deputy Chief Counsel in the Office of Legislative Counsel. The committee vote was 4-1-0, and we asked the Senate for its concurrence.
The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Government Operations? Senator from Chittenden.
Thank you, Mr. President. If I might ask a question of the presenter.
The reporter is interrogated.
I understood the senator to be talking about constitutional issues involving the legislature, and that this is to mitigate those or eliminate them. I'm wondering if the senator could walk us through a complaint. Let's say a complaint was brought forward against someone in this body. What would that procedure look like, Mr. President?
I appreciate the question, Mr. President. What will happen is that the State Ethics Commission can refer the complaint to either the Senate Ethics Panel or the House Ethics Panel. As it was passed last year, it would have required those panels to consult with the Ethics Panel before they made any determination. There's no requirement that would eliminate either panel or the judicial branch or executive branch from seeking advice from the State Ethics Commission. The constitutional pivot, if you will, was that it would have been required before those panels could act on it.
And so, if I understand, Mr. President, they would issue a finding with recommended action to our Senate panel. Is that correct?
Again, I appreciate the question. The State Ethics Commission would refer a complaint with any specific reference to the state code of ethics, and then offer whatever advice that they took. But it would not require either panel or the judicial branch or executive branch just to seek prior consultation.
And the final question I would have is, that advice that goes to our panel is then advisory, not mandatory.
Exactly.
Thank you very much, Mr. President. And I thank the committee for their work.
Senator from Washington,
Thank you, Mr. President. May I inquire of the presenter?
the reporter's interrogated.
I heard at the beginning of the presentation something about funding, and maybe I missed it as I was reading through here, but I wondered if that is the delay. Also, I didn't hear the explanation of why the delay to 2027. And so I just wondered if we could get more information about the funding question, because that funding implications of the bill we passed was definitely brought to our attention by the Ethics Commission in appropriations and the need for more funding. So I wondered if the committee talked about that, and if I could hear more about why we're delaying to 2027 to give them that authority.
Appreciate the question, Mr. President. We did indeed hear from Christina Siebert, who is the Executive Director of the Ethics Commission. I don't remember the specific request that they made to the Senate Appropriations Committee. I think it was for two positions, including a staff attorney. But once we had received word that the funding was not going to be available, again, because of the lack of having an attorney on staff, we felt it prudent to at least take a couple of years for possibly future appropriations to be included.
Okay. Thank you, Mr. President.
Are you ready for the question? The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Government Operations? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay.
Nay.
The ayes appear to have it. The ayes do have it. And you have proposed to the House to amend the bill as proposed by the Committee on Government Operations. The question now is, shall the bill be read a third time? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay.
Nay.
The ayes appear to have it. The ayes do have it. And you have ordered third reading of H1. We have on the calendar for action H44, an act relating to miscellaneous amendments to laws governing impaired drivers. It passed the House January 21st of 2025. It was referred to the Committee on Judiciary, which reports it has considered the bill and recommends that the Senate propose to the House to amend the bill as it appears in today's calendar, and that with such proposal of amendment, the bill ought to pass. Affecting the expenditures of the state, the bill was referred to the Committee on Appropriations, which recommends that the bill ought to pass in concurrence with proposal of amendment as recommended by the Committee on Judiciary. Listen to the second reading of the bill.
H44, an act relating to miscellaneous amendments to the laws governing impaired driving.
I recognize the senator from Franklin District, Senator Norris, for the report of the Committee on Judiciary.
Thank you, Mr. President. You can find or follow along on page 1607 of today's Senate calendar. H44 General Overview. Before the Chamber is the Senate Judiciary Committee Strike All Amendment to H44, entitled An Act Relating to Miscellaneous Amendments to the Laws Governing Impaired Driving. This bill proposes to make a variety of changes to the impaired driving laws, including technical corrections, closing loopholes to ensure that the DMV is notified of license suspensions, and creating proportionate accountability for non-compliance with warrant-based blood draws, among other changes. Now to the bill, Section 1. Beginning with Section 1, this portion of the bill amends Title 4 VSA 33A concerning the jurisdiction of Family Division of Superior Court. Specifically, this section makes technical corrections by striking the term juvenile and adding a reference to 33 VSA Chapter 52A, the Youthful Offender Chapter, to proceedings within the jurisdiction of the family court. These technical changes reflect the realities of the Family Division to hear delinquency and youthful offender cases related to DUI violations. The term juvenile is not a precise legal term. Additionally, changes to the statute are made to comply with federal masking regulations for commercial drivers. The federal government created the commercial driver license system to, in part, reduce the number of truck and bus accidents and to remove unqualified truck and bus drivers from the road. To identify dangerous drivers, states must accurate and timely information about the driving history of CDL holders. As a result, the federal regulations prohibit masking, which occurs when a court permits the conviction of a CDL holder for a traffic violation to be deferred, dismissed, or go unreported. The changes you see to the statute ensure that masking in violation of federal laws does not occur for CDL drivers in Vermont. Finally, 4 VSA 33B is amended to also make technical changes by clarifying terms, ensuring that felony motor vehicle offenses can be heard in the Family Division, and to ensure that the Family Division court decisions are reported to the Commissioner of Motor Vehicles. Section 2. Section 2, it amends various parts of Title 23 VSA Chapter 13, Subchapter 13. The first amendment you will notice is the addition of serious bodily injury to the definition section of the subchapter. As you will see later in the bill, this is a cleanup of various cross-references to the term in 23 VSA 2010. Moving to the amendments in 23 VSA 1201, you will notice that general neutral terms are now proposed, but more substantively, a new subsection J is added, mandating compliance with the collection of an evidentiary blood sample issued through a warrant. The Senate Judiciary Committee amended the language proposed by the House in subsection J to help mitigate against any implied consent issues. As a result of the language proposed by the House and changes recommended by the Senate Judiciary, a failure to submit to an evidentiary blood sample would result in a charge of criminal refusal of an evidentiary test. However, the proposed amendment to subsection F ensures that a person cannot be convicted of both a DUI violation and a criminal refusal. The prosecutor must choose. With these proposed changes, it is important to understand the situation in which a police officer can obtain a blood sample in the DUI context. Under our implied consent law, 23 VSA 1202, a person has provided implied consent to a blood test if 1, breath testing equipment is not available, 2, the person cannot give a sufficient breath sample, or 3, when the police officer has reasonable grounds to believe that the suspect is under the influence of drug or other alcohol. However, in any of those circumstances, the police officer must obtain a warrant due to the intrusive nature of a blood draw. That warrant requirement is embodied in 1202F. To ensure a person's understanding of the consequences, DUI suspects are informed by a police officer of certain statutory information under 1202D6. H44 further amends this portion of the law to ensure that a DUI suspect is aware that they could be charged with a criminal refusal for failing to submit to a blood test issued through the warrant. The Senate Judiciary Committee recommends amending the proposed language from the House by adding knowingly hinders. to subdivision D6 to hedge against situations where someone could be charged with criminal refusal when the person is incapacitated due to substance abuse. Put simply, the person must be aware that the person's actions could hinder the collection of the blood sample to be prosecuted for criminal refusal. Moving on to 23 VSA 1205 concerns a civil license suspension procedure related to a DUI charge. H44 resolves an unintentional gap in the law between 1201 and 1205. Section 1201 creates a criminal offense if someone possesses a BAC of 0.08 or higher. However, Section 1205 currently creates a civil violation if the person possesses a BAC of over 0.08. H44 amends Section 1205 so that it's consistent with 1201 by reading that a violation occurs at or above the legal limit of 0.08. You will also notice that 1205C is amended to ensure that the Commissioner of Motor Vehicles receives the police officer's affidavit of probable cause when someone is provided a notice of violation. This ensures that the DMV has the information necessary to suspend someone's license if adjudicated accordingly. Next, as I mentioned previously, provisions related to DUI penalties in 23 VSA 1210 are also amended. These amendments ensure that a separate DUI violation can be charged for each person that dies. Moving on to our next page. Or has serious injury in the same DUI-related crash. Previously, the statute restricted such an enhancement to crashes that only resulted in death or crashes that only resulted in serious injury, but not both, which leads to an unnecessary restriction. Sections 3 and 4 of this bill amends 33 VSA 5202 and 5229 to ensure that the Commissioner of Motor Vehicles receives any merits adjudication orders concerning the potential license suspension of someone in a family court proceeding. This is the one of the reporting loopholes, closing measures I mentioned before. Section 5 of the bill creates the Impaired Driving Processing Task Force. The task force is created to study the concept of implied consent during DUI investigations with the dual goals to recommend constitutional approaches that, one, minimize the length of a law enforcement encounter for a suspect, and two, minimize the processing and paperwork requirements for law enforcement officers. The task force is comprised of the Chief Judge of the Superior Court, the Commissioner of Public Safety and Motor Vehicles, the Defender General, the Director of State Department of State's Attorneys and Sheriffs, the President of Vermont Sheriffs Association, a representative of the Vermont Police Association. A report in the form of proposed legislation is due to the House and Senate Committees on Judiciary by November 15th of 2025. Finally, Section 6 states that the bill shall go into effect July 1 of this year. Senate Committee on Judiciary heard from the following witnesses: Wade Cochran from the Director of Enforcement Safety, Department of Motor Vehicles; Benjamin Novogrodsky, Legislative Counsel, Office of Legislative Counsel; Marshall Paul, Defender General and Chief Juvenile Defender, Defender General's Office; Dennis Weigmans, Traffic Resource Prosecutor, Department of State Attorneys and Sheriff; Thomas Zone, Chief Superior Judge, Vermont Judiciary. The vote in your hardworking Senate Judiciary Committee, Mr. President, came out 5-0-0, and we ask for the Senate's support. Thank you.
Well, Senator, sounds like your hard work paid off. I would now like to recognize the senator from Franklin District, Senator Norris, for the report of the Committee on Appropriations.
Thank you, Mr. President. Senator Appropriations heard from the reporter of the bill, Ledge Council and JFO, and we voted this out on a 4-0-3 motion due to the fact that many of our hardworking members of Appropriations were in the conference committee, and this has a de minimis effect on the state's budget. Thank you, and we ask for the Senate's support. Thank you.
The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Judiciary? Senator from Addison.
Thank you, Mr. President. May I inquire of the reporter of the bill?
The reporter is inquired of.
Mr. President, during the report of the bill, I heard the term masking used, and I've been looking to try to find that defined. It has certain connotations, particularly after the pandemic, and I can't find it defined in here. So I wonder if the reporter could explain what masking means.
Thank you, Mr. President. Thank you for the question. I will make every attempt to. The federal masking requirement is the Federal Motor Carrier Safety Administration requires that states comply with any violations that have occurred in their states to report to Department of Motor Vehicles. The Code of Federal Regulations requires the state to report these CDL convictions promptly within 10 days. The state must not mask, not as in the masking as we all know. Let me give you, I have several examples. I can just give you one. Driver's charged with using a cell phone. Okay, there's no reductions offered. Driver pleas as charged. The court allows withdrawal of the plea and enters new plea to be a lesser charge because driver complains his or her CDL license would be revoked if convicted of the original charge. Is this masking? Yes. That's one example. I can go on with another one,
Okay.
but that's the generic.
All right, Mr. President, unfortunately, that doesn't clarify it for me. Is it masking is it that state law can't mask what federal law is? Is that what it means? I see the legislative counsel nodding his head over there, but is that what it means, Mr. President?
Thank you, Mr. President. I believe that nod is for me. That would be yes.
Okay. Thank you, I thank the reporter.
Are you ready for the question? Senator from Windsor.
Thank you, Mr. President. May I inquire of the presenter of the bill?
The presenter is interrogated.
Thank you, Mr. President. I was surprised to see a bill related to impaired driving not having had a stop in Senate transportation because one of our main goals is also public safety on our roadways. But I did want to ask, generally, do you think this bill will increase or decrease CDL driver licensure being taken away? Will we see more CDL licenses being removed or revoked or fewer?
Thank you, Mr. President, for the question. I don't believe the purpose of the bill is to remove CDL drivers from the highway. The purpose of the bill is to stop any masking. And as soon as this becomes law, I believe it becomes evident to CDL drivers that they can no longer attempt to do this, and hopefully the courts will take notice of this procedure.
I think I understand what you're saying. So do you expect then that more individuals who perhaps by the definition of the bill are still driving with a CDL when they otherwise shouldn't be allowed to drive with a CDL, those folks would be found out to be inaccurately or illegally driving with a CDL license and it would be taken away? Is that kind of the point of it? There are people who are in violation of the law that the feds don't know about that then will have their CDLs taken away?
I can't comment on that. I would assume that would be the purpose of the bill, yes.
Okay. I thank the presenter for their remarks. I really would have hoped we could have had more of a discussion about this in transportation. While I respect the intent of the bill to properly, if I'm understanding correctly, and I'm happy to wait for information on third reading on it, but I do have concerns that CDL licenses are, we're getting fewer and fewer folks who can actually gain access to a CDL license, and that is requiring exceptionally long driving hours for folks who have CDLs. It's forcing, I would say, shortages when it comes to access to our workforce with drivers. And one of the key concerns we heard with our volunteer driver workforce, actually with medical transports, was folks who had previous maybe offenses on their license, but had it not become an issue enough where they had their CDL revoked, but they were being caught up in a background check and then were not able to drive in a volunteer fashion. So I'm worried that we're going to lose drivers, and if that's inaccurate, I would love to have that corrected, and I'm happy to get information from our enthusiastic legislative counsel on the topic before third reading, or perhaps a offline conversation with Senate Transportation so we can understand the implications of reduced licensed CDL drivers in our state. Thank you.
Senator from Franklin.
Mr. President, may I ask for a brief recess to confer with
We will
legislative
take a
counsel?
brief recess.
Altman's still
And I know he's not gonna be unhappy with it.
Will the Senate please come to order?
Yeah.
Senator from Franklin.
Thank you, Mr. President.
Say it.
I believe and hopefully the questions from the senator from Windsor and the senator from Madison County have been addressed. Unless they have some further questions, I'll be more than happy to entertain those. Thank you.
I would
Senator from Windsor.
Thank you, Mr. President. I would just agree, and I really appreciate the senator having us connect with legislative counsel. My understanding now is this is bringing us into compliance with federal law, and that makes me feel much more comfortable with the discussion.
Seems like the Committee on Judiciary didn't work quite as hard as the senator from Franklin thought. The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Judiciary? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and you propose to the House to amend the bill as proposed by the Committee on Judiciary. The question now is, shall the bill be read a third time? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and you have ordered third reading of H44. We have on the calendar for action H50, which was passed by the House January 21st. Somebody wrote that really small. 2025. It was referred to the Committee on Institutions, which reports it has considered the bill and recommends that the Senate propose to the House that the bill be amended as it appears in today's calendar, and that with such proposal of amendment, the bill ought to pass. Listen to the second reading of the bill.
H50, an act relating to identifying underutilized state buildings and land.
I recognize the Senator from Orleans District, Senator Douglas, for the report of the Committee on Institutions.
Thank you, Mr. President. As the chamber will see, it is a one-page bill, so I will try not to belabor the point here. The current system for the Department of Buildings and General Services, the commissioner maintains an inventory known as the Space Book. And the process for that is every 2 years, the commissioner will compile all the state-owned buildings together into one format, and may additionally request from the head of every agency to submit all their buildings and how they use those spaces. And you'll see in either on 1621 of your calendar or on the original bill itself from the House, you'll see that their operations can include inventory square footage, that's an actual use, not in use, used for storage, that's unfinished, and on and on. The House is amending that part of the statute by adding "and land," and then instead of having it be by the request of the commissioner, it's going to be annually, automatically, annually. And then you'll also see that they're also prescribing that the head of every agency also indicate in its inventory whether any buildings that they have under their jurisdiction are vacant and whether any of the land that they have is unnecessary for state purposes. And then also that on or before January 15th of each new biennium, the commissioner of BGS will submit to the House Committee on Corrections and the Senate Institutions Committee that inventory. So we'll get a copy of the Space Book automatically every 2 years with all of these new prescriptions in the bill. Now, your Senate Committee on Institutions, we are also hardworking, and we added in 2 words. So you'll see that it's a strike all amendment for adding in the words "or state leased" in the beginning of the bill. Mr. President, we heard from the sponsor of the bill in the House. We heard from the Legislative Council. We heard from the Commissioner of the Department of Buildings and General Services, and we heard from the Director of Planning and Property Management of BGS. Our committee voted 4-0-1 on this bill, and we ask the Senate support. Thank you, Mr. President.
The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Institutions? Senator from Windsor.
Thank you. The Windsor delegation is consistent. And so, Mr. President, may I inquire of the reporter of the bill?
Yes, you may.
The town of Windsor has several buildings and property that is underutilized, which we have discussed already in this chamber. And we understand that there was discussion in the last 2 days in the Senate Institutions Committee about the former Windsor prison site, which fits right in here as an underutilized and in fact unused set of buildings and underutilized land. And I am just, given that it sort of perfectly fit into the intent and world of H50, I'm just curious how that discussion went, Mr. President.
Mr. President, thank you for the question. The senator is correct. Yesterday, I believe it was, we did hear some testimony from the vice chair of the select board of Windsor, as well as the town manager of Windsor. And the general consensus of our committee was that that proposal is being brought very late in the process for this bill. And I believe that we need more information to go off of, and I believe our committee had decided not to take action on that, Mr. President.
Thank you, Mr. President. I don't think anything's late that's been hanging on the wall for 10 years.
Yeah.
I think that this is an issue that is unresolved and really is calling out for resolution and is something that the Institutions Committee really is their responsibility to move forward. And I would really appreciate the committee considering an amendment of some variety on how we move forward on this, whether they choose the amendment that the Windsor District Senators brought forward, or whether they have an idea of their own on how we can move this issue forward, we would appreciate. Thank you.
Thank you, Senator.
Senator from Washington.
Hey, Mr. President, may I inquire of the presenter of the bill?
The reporter is interrogated.
Thank you, Mr. President. My question comes with the context of move at the federal level to sell off public lands, which is deeply concerning, I think, to a lot of folks, particularly as it pertains to national parks, et cetera. And so my question is about subsection G, this last sentence that you've added here about whether any land is unnecessary for state purposes. And I'm wondering about that last statement there, for state purposes. Did the committee have any discussion about, is there a list of state purposes? Is that in reference to anything?
Thank you, Mr. President, for the question. So I do not believe that our committee had discussion on that particular part of the bill. And I will clarify that that part of the bill did not come from our committee, that came from the House. Just a point of clarification there. But no, Mr. President, I do not believe we had any discussion relating to the federal implications of that line.
Thank you, Mr. President. I appreciate that. And I may want to just flag that I may want to just chat with our legislative counsel about if there exists such a list, if there could be a reference added or something like that to make it clear what the what the state purposes are, so that ideally that we can clarify that, for example, state parks are a part of state purposes, just as an example. So just having some clarity there, I think may be helpful. But anyway, happy to chat further either with you or with the committee or with the senator or the committee about that. Thank you very much, Mr. President. And I thank the senator.
Are you ready for the question? The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Institutions? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and you've proposed to the House to amend the bill as proposed by the Committee on Institutions. The question now is, shall the bill be read a third time? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and you have ordered third reading of H50. We have on the calendar for action. Oh, we're skipping over that one. We are passing over H482. We are passing over S87. That brings us to H167, an act related to establishing Vermonters Feeding Vermonters grant at the Agency of Agriculture, Food, and Markets. Are there any amendments prior to third reading? Listen to the third reading of the bill.
H167, an act relating to establishing the Vermonters Feeding Vermonters grant at the Agency of Agriculture, Food, and Markets.
The question is, shall the bill pass in concurrence? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and we've passed H167 in concurrence. We now have H266, an act relating to 340B prescription drug pricing. Are there any amendments prior to third reading? Listen to the third reading of the bill.
H266, an act relating to the 340B prescription drug pricing program.
The question is, shall the bill pass in concurrence with proposal of amendment? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and we have passed in concurrence with proposal of amendment H266. We have on the calendar for action H505, introduced on April 11th of 2025. It was referred to the Committee on Government Operations, which reports it has considered the bill and recommends that the bill ought to pass in concurrence. Listen to the second reading of the bill.
H505, an act relating to approval of amendments to the Charter of the Town of Barry.
Recognize the senator from Orange, Senator Hart, for the report of the Committee on Government Operations.
Mr. President, the act relating to the approval of the amendments of the Charter of the Town of Barry. Section 1, General Assembly of Barry Town approved the amendments of the Charter of the Town as set forth in this act. Voters approved the proposal of the amendments on May 14, 2024. The voters at that point voted to eliminate the auditors and to have the select board contract with a public accountant in lieu of it. Their vote was 1,173 yeses, 257 noes, undervotes of 133 for a grand total of 1,573. This is the message we got from Tina Lunt, the Barry Town Clerk. Okay. They chose that day also during on May 15th. I'm sorry, May 14th. They chose that day to elect a clerk and a moderator during their town meeting. Their comprehension and fees, the town elected that day in their annual vote to pay the select board, the Board of Abatement, and all fees prescribed by the state law, charter, ordinances, and others wise shall be collected for the benefits of the town and paid to the town treasurer. No fees shall be used directly by any receiving officers or in lieu of directly to the officer. There was on section 3, there is a repeal for the auditors. The effective date shall take place upon passage. Our committee heard from Representative Topper McFawn from Barry Town, and Legislative Counsel Tucker Anderson on this bill. It passed our government operations 500, Mr. President. Thank you.
The question is, shall the bill be read a third time? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and you've ordered third reading of H 505. That completes the orders of the day. Senator from Chittenden.
Thank you to senators for a short session again. We're trying to give our finance committee as much time as they can possibly work in today. So with that said, Mr. President, I would move pending announcements that the Senate stand in adjournment until 11:30 a.m. Friday, May 16th.
Are there any announcements? Senator from Chittenden.
Thank you, Mr. President. I know as we get close to the end, we all are nervous and we're concerned and stressed. And I'd just like to remind us as senators to maintain decorum in the chamber. And especially when a presenter is speaking and you've finished questioning, allow for the presenter to sit down and then proceed with your remarks. So thank you, Mr. President.
Are there further announcements? Senator from Washington.
Thank you, Mr. President. Senate Finance will meet at 2 o'clock.
Are there further announcements? Senator from Rutland.
Thank you, Mr. President. Government Operations will meet at 2:15.
Are there further announcements? Seeing none, the senator from Chittenden has moved that the Senate stand in adjournment until 11:30 a.m. Friday, May 16th, 2025. Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and we'll stand in adjournment till 11:30 a.m. Friday, May 16th, 2025.